Hey everyone, Joe Gentili from Saraf Gentili LLP. Today I want to talk about. I've mentioned this case before in a video, but I want to do another one on it because it's just that important. There's a Supreme Court case that's coming up called Loper Bright, and this case has the possibility really to have just a real sea change in immigration law and how it's interpreted and how it's going to be applied. So the current state of the law, which is based on this case called Chevron, is that essentially agencies get a lot of deference for how they interpret laws and regulations with regards to immigration law. So the courts will give the agencies a lot of deference, and in some instances, really complete deference. So there's a lot of power in the agencies like USCIS in how immigration law is applied. So right now, what we have is a situation where, since the agencies have so much control, who's president and which administration is in charge has a lot of impact on immigration law as well, because they control the agencies. So we see really big swings in immigration law and how it's interpreted sometimes depending on who's president. And we see a lot of power concentrated in the hands of the agencies. And so if they decide to exercise that power in a way that's not favorable towards people going through the immigration process, it's going to apply across the board to everybody going through the agencies. So what Loper Bright has the possibility of doing is overturning that Chevron case, which would effectively shift a lot of the power away from the agencies and towards the federal courts. So that can bring about a very big change in how immigration law will work if Chevron is overturned. And so what we'll see there is that judges are going to have a lot more power. Federal judges are going to have a lot more power as to how immigration law is applied, and agencies are going to have less power. So if the agencies take a position that's against you, if you're going through the immigration process, if judges have more power, then that means that you may have a better chance to fight the agency's interpretation in court. So it can give immigrants another bite at the apple if the agency is hostile. You're also going to see what I think would happen is, like right now, since the agencies have control, a lot of, not all, but a lot of immigration law is pretty uniform, and doesn't really matter where in the country you are. The rules are going to apply the same. There's a lot of exceptions to that, especially when you get into removal, but by and large, that's the case. What we'll see is because the federal judges are now going to have more control, is that you'll see immigration law being really interpreted differently depending on where in the country you live and what court system you're under. So, for instance, it's pretty foreseeable that you'll see that immigration law will be interpreted more permissively, more favorably to immigrants, for instance, in New York or California than it may be in Texas. So you're going to see bigger distinctions brought up by that, which is not necessarily a bad thing. It could be a bad thing if you live in a district where the laws are interpreted very harshly towards immigrants, but the good news is that you have options. So if you do live in a place where the laws are interpreted harshly, you could move to some place where maybe they're interpreted more favorably for you, or just don't move to a place where they're interpreted harshly to begin with. So yes, there's going to be some areas of the country where the immigration laws will probably be interpreted more harshly, but you have the option to go elsewhere within the country if that's the case. So it's hard to foresee just exactly how everything is going to turn out change-wise, but I think there's one point that's really pretty certain. If we see this change where the judiciary, the federal judges, have more control over immigration than they do now, and the agencies have less, you're going to see a lot more cases being brought in federal court. Immigrants are going to be suing a lot more in federal court, and you're going to see those cases are going to be a lot more consequential to how immigration law is applied throughout the country. So you're going to see, I think, a shift in immigration law practice as well, where federal immigration work is going to become a bigger part of immigration law. So, for as a law firm that specializes in federal litigation, I suppose this is a development that's helpful for us, because this will allow us to help more people, and it'll allow us to have more of an impact overall on how the immigration system is administered, and not just us, but all lawyers that focus on federal litigation. So it's a little exciting, it's a little scary, but I think most observers of the Supreme Court seem to be thinking that this Chevron decision is going to get overturned, or at least overturned in part. So it'll be exciting to see what happens. And it could be good news for some people. There are people right now that their immigration situation may look hopeless because of an agency action that can't be challenged, where if this decision goes the way people think it will, then they may have a shot to get that reversed in federal court where they don't now. So, there's reason for some people to be optimistic about this case. So anyway, that's my thoughts on Loper Bright. And just to basically summarize, I think it could have a really, really big impact on immigration law. So it's something to keep an eye on. Thank you. I hope this video was helpful. If you have any questions, please feel free to reach out. Thanks. Bye.